Hello everyone and welcome to today's Mondac webinar in association with Fabian Privacy Legal, who will be exploring the important requirements under the Swiss Data Protection Act and how you can be compliant with it. My name is Dan Sampaio and I'm joined by a brilliant speaker to take us through today's discussion. Daniela Fabian is the founder and executive director of Fabian Privacy Legal, a boutique law firm specialized in international, European and Swiss information and data protection law, governance, risk management and program implementation. Daniela is a Swiss attorney at law and certified privacy professional with more than 30 years of professional experience, including as global head of data privacy at Novartis for many years. She advises multinational companies in the EU, Switzerland and the USA on data protection and security issues. Now, before I hand over to Daniela to begin today's webinar, a quick housekeeping item. You are able to submit questions to Daniela by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to get those questions in. It's now my pleasure to hand you over to Daniela to begin. Thank you.
Thank you very much, Dan, for this introduction. Welcome to this webinar. 1 year on, Mastering Compliance with Switzerland's Data Protection Act. So 1 year after the entry into force of the new Swiss Data Protection Act, we will recap the most important requirements under the revised law and have some more detailed look into some selected requirements, such as data breach notification and data security and how to comply with those requirements. And furthermore, we will discuss experiences and developments and also look at some opinions of the Federal Data Protection and Information Commissioner in the last year. This webinar focuses mainly on the processing of private organizations, so not federal bodies. They are also covered under the law, but there are some specific rules for federal bodies. And finally, this presentation builds upon the 2 previous presentations, and you can find those on the Mondac platform. Okay, next slide, please. Next slide, please. Okay. So, whenever personal data is processed, there are some principles to be adhered to. Most of you will know those. Also, under the GDPR, we have similar principles. So, personal data must be processed always lawfully and in good faith, and not infringe any rule or any laws, or adversely affect the personality of individuals. So you cannot do something that would infringe another law. The principle of proportionality or data minimization means that the processing must always be necessary, adequate, and appropriate to the specific purpose. We have the principle of purpose limitation. So that means that personal data that is collected for one specific purpose may not be used for another purpose. And here in this respect, it's always also important, if you write a privacy notice, that you think about the purposes and that you really are transparent on these purposes from the outset. Because if you want to change, then you need to be transparent again, and you need to have a legal justification to do this. Storage limitation or data retention principle. This means that personal data must be deleted, destroyed, or anonymized as soon as this data is no longer needed. Of course, there are also legal retention requirements, and these requirements must be adhered to. Next slide, please. Yeah, the principle of data accuracy means that personal data must always be accurate. The law requires controllers to make sure and to ascertain that the data is accurate. So you have to take some action to really ensure that the data is accurate. And if this is not the case, then the data must be corrected or eventually also deleted or destroyed. Personal data must be protected. with organizational and technical measures against unauthorized processing. There is an ordinance to the Data Protection Act, and this ordinance provides some specific requirements. I mean, not too specific, but at least some additional criteria on what this means, on what the level of the technical measures should be, and I will talk about this just in a minute. Then finally, personal data may not be processed against the express declaration of intent without justification. So if somebody says, I don't want my data to be processed, then this can be done nevertheless, but only if there is a justification. And the same thing is if sensitive personal data should be shared with a third party. Again, this is only allowed if there is a justification. I will talk about justification also later on. But so these are the principles that apply always when personal data is processed. Next slide, please. Exactly. So now if anyone that processes personal data against these principles that I just mentioned, then this processing would be unlawful. And that means that in these cases, a legal justification is required. So, for example, as I mentioned before, you process the data for a specific purpose and you change the purpose later on. If you want to do this, you need to have a legal justification. If somebody says, I don't want my data to be processed, you can do it if you have a legal justification. Or if you want to share sensitive personal data to a third party, again, you need to have a legal justification. But beside that, under the Swiss Data Protection Act, processing personal data does not require a legal justification, as you know, for example, under the GDPR and also other laws that always require legal justification. This is not the case under the Swiss Data Protection Act, as long as the principles are met and the processing is in compliance with these principles. Okay, next slide, please. Here's a summary of the data privacy rights under the Data Protection Act. So we knew some rights already in the past. There is the right to request access to personal data. We know that right also from other laws. What is new that there is now a right to data portability. There is the right to request the deletion of personal data. We had that before. There is a right to request the processing of personal data be prohibited. There is a right to request that the disclosure of personal data to third parties be prohibited. And there is the right to request that the measures regarding deletion and non-disclosure be published or communicated to third parties. So these are the rights that data subjects have, and they can claim these rights at the civil court. Next slide, please. So on this slide, and we will go into more details now, are the most important requirements under the Swiss Data Protection Act. It's a selection, it's not all, but I think these are the most critical ones. There is a duty to appoint a representative in Switzerland under certain conditions. The appointment of a DPO is not mandatory under Swiss law, but there are some benefits by doing that. There is a duty of information, which has been extended in relation to or in comparison to the previous version of the law. There is now a data security breach notification requirement to the authorities and also to data subjects under certain conditions. There is a duty to perform data protection impact assessments. There is a change in the inventory. Before, under the old Data Protection Act, controllers had to maintain a record of databases or data files. Now we have the obligation to maintain a record of processing activities with some exemptions. The technical and organizational measures are mostly unchanged. There is a duty to take some steps when outsourcing personal data to a to a processor. We had that before, but there is one change, and cross-border data transfers are still more or less unchanged. We had that before. Let me go a little bit more into details. Next slide, please. So one important aspect is also the risk-based approach that has been introduced into the law. So certain obligations depend on the level of risk and apply only in case of high-risk processing. And I have mentioned a couple that really specify this high risk. So the obligation to appoint a representative in Switzerland depends on the high risk of processing, among other criteria. The obligation to notify a data security breach, again, is only for high-risk processing activities. The obligation to perform a DPIA, again, high risk. And the obligation to keep a record of processing activities. So for organizations that have less than 250 employees, generally there would be an exemption to maintain this record of processing activities unless the processing is a high-risk processing. So you see that there are specific areas where high risk plays a significant role. The law does not really clearly specify what the high risk is, but it can be derived generally from the nature. So for example, profiling allowing the assessment of essential aspects of the personality of the individual, the extent, so if it's at a large scale, the circumstances, for example, if the data subject is a subordinate of the controller, and also the purpose of the processing. So these are the criteria that have to be looked at in order to decide whether there is a high risk or not. The law then says that, or mentions basically two criteria. When these criteria are fulfilled, then high risk is considered. So first, the extensive processing of sensitive data. So extensive in the sense it's not limited or occasional. And the systematic and extensive surveillance of public areas. So in these cases, the law says then it's a high risk. And then, for example, a DPIA must be performed. But it's not the only, these are not the only criteria. You have really to look at this full criteria, nature, extent, circumstances, and purpose, and then decide if there is a high risk or not. Okay, next slide, please. Now we will look a little bit more into details in these areas that I have listed here. So applicability of the FADP, the appointment of representative and DPO, the duty to inform, the DPIA, the record of processing activities, data security and security breach notification, outsourcing and cross-border. Next slide, please. So in Switzerland, we have the so-called impact principle. That means that the FADP applies to matters that have an impact in Switzerland, even if they are initiated abroad. So to assess this impact and to assess new organizations, if the FADP applies, we have to see if the organization has its registered office in Switzerland, then it's clear. If processing takes place in Switzerland, or if natural persons affected by data processing, so the data subjects, have their usual place of residence in Switzerland. So in these cases, the FADP would apply, and if none of these criteria are met, then the FADP would not apply. Next slide, please. So as I mentioned before, the law introduced now this obligation to appoint a representative in Switzerland. We know that also from the GDPR that has this requirement. However, the criteria are quite stringent, and I think in a few cases it will be really necessary to appoint a representative. All these conditions that I have listed here must be met. So the organization processes personal data of persons in Switzerland. That's the first criteria. And the data processing is connected to offering goods or services in Switzerland or monitoring the behavior of these persons. We know that also from the GDPR, this criteria. And this is new, the processing is extensive. It is a regular processing, so not an occasional processing, and the processing involves a high risk for the personality of data subjects. So no, if you would, for example, conduct clinical trials in Switzerland, then probably these elements would be, or this criteria would be met. But really, this is really an assessment that needs to be done, and probably there are not too many cases where a representative needs to be appointed. Next slide, please. So if a representative needs to be appointed, then this should be done in writing. I mean, this is a recommendation at least. And the duties should be, the recommendation is to write down the duties, which is to keep a register of the processing activities, and the law defines the minimum content. On request to provide the Federal Data Protection and Information Commission, so FDPIC, with the information contained in the register, so they can really request that from the representative, and on request also to provide the data subjects with all the information on how to exercise the rights. The name and address of the representative must be published. Generally, this would be done in a privacy notice or just on the website somewhere which is visible. Next slide, please. So the appointment of the data protection officer, as I mentioned, is not mandatory. So really each controller is free to decide whether to appoint a formal one or not. The tasks of the DPOs are mentioned in the law. So the DPO would be the point of contact for data subjects and authorities. And the duty is to train and advise the controllers on data protection issues and to provide assistance in the implementation of data protection. Now, there is a benefit if organizations generally perform high-risk processing and therefore needs to perform a data protection impact assessment. Then the law says if there is a residual risk, then the data protection authority must be informed about this. But if the organization has appointed a DPO and consults the DPO for these high-risk processing activities and for the DPIA, then it's not necessary to consult with the authority. So that means that for organizations that process or that perform high-risk processing activities in Switzerland, maybe it's a good idea to appoint a formal DPO. And for the others, it's not mandatory. Of course, it's always good to have somebody that takes on these roles, but it would not be necessary to have a formal one. Formal means that the DPO again needs to be published in the privacy notice and must also be notified to the authority. Next slide, please. Yeah, this is basically what I already said. So it's really a question or a determination for each organization based on the types of personal data and of the processing activities that you have. Next slide, please. So a very important aspect is transparency and the duty to inform, so the privacy notice. Before the revision of the law, it was only required to inform if sensitive personal data was processed. And now the duty of information or privacy notice requirements were extended. So now the controller shall adequately inform data subjects about any processing of any collection and process of personal data, be it a direct collection or indirect collection. There are some exceptions where information is not needed, and these exceptions go a bit beyond the exceptions in the GDPR. So data subjects already have the information, that they do not need to be informed again. Processing is provided for by law. The controller is bound by a legal obligation to secrecy. And also if it's an indirect collection where information is not possible or requires disproportionate effort. In these cases, it's not required to inform data subjects, but otherwise you always have to inform. There are also some restrictions and or waivers or postponements. For example, if it's required by overriding interests of third parties not to inform, or if the information prevents the fulfillment of the purpose of the processing. I don't know, there is an investigation needs to be conducted and you would not, you wouldn't want to inform beforehand, or also the controller has an overriding interest and does not disclose data to a third party. And so in these cases, it might be that the information may be provided a little bit later or could be restricted. Next slide, please. So if you have to inform, and you have to inform as a general rule, so you have to determine who you have to inform, so the website users, employees, job applicants, customers, suppliers, consumers, patients, etc. So which one are the target groups? Ensure that the privacy notice contains all the required minimum information, which is similar to the information that we know also under the GDPR. It's of course the identity of the controller, if applicable of the legal representative and the DPO, the purpose of processing, the recipients or categories of recipients, the categories of personal data if they are collected indirectly, and for cross-border data transfers, and that is different, the state and applicable transfer mechanism. So you have to say in the privacy notice in which states the data might be transferred, not only third countries, but generally. So if the data is transferred to Germany and France, you have to say that, Germany and France. If the data is transferred also to the US, then you have also to say based on which legal mechanism this data is transferred to the US. So this is something that is in addition to the requirements under the GDPR. So for those that have privacy notices based on the GDPR, just think about this additional requirement. In addition, if there is automated individual decisions that are made, then this needs also to be mentioned in the privacy notice so that data subjects know about this. And then any other information that ensures transparency and that helps us to exercise the privacy rights. So the law is not specific about this additional information, but generally you can also again look into the GDPR and look what it is. For example, data retention period and or maybe the rights that people have, etc. So this depends a little bit on the processing activity actually. But so anything that is important for data subjects so that they are really fully aware of what's happening and that they can exercise their privacy rights. You have to respect the deadlines. So if it's a direct collection, you have to tell at the time of collection. If it's an indirect collection, then not later than 1 month after receipt of the data, or earlier if the data is disclosed. So how to inform? This is always a question that we get. You can inform via the website privacy notice, cookie notice, customers, and customer and supplier notice, employee notice, job candidate notice, etc. So some people put everything in one notice, others split all the notices for each category of data subjects. So this is really something that each organization should decide. And how, via the website, contracts, terms and conditions, disclaimers in emails with references maybe to the website, in invoices, order forms, whatever. So there are many ways on where to put the privacy notice or where to put a reference with a link to the privacy notice. Maybe just one thing that is important to know. So the sanctions under the Swiss law are sanctions for individuals and only for specific violations. So this is one. So if data subjects are not correctly informed about the data processing, then that could lead to a sanction up to 250,000 Swiss francs. However, it must be done with intention, and so this is something that, again, I mean, it's probably not so often that people would really get a fine for this, but you have to be careful to be really or to provide really complete information. Okay, next slide, please. Yes, so the Data Protection Impact Assessment, DPIA, this is a new requirement under the law. We know that, again, we know that from the GDPR, but under Swiss law it's a new requirement. So the controller shall conduct a DPIA if a planned data processing operation may entail a high risk to the personality or fundamental rights of data subjects. So again, the high risk, we discussed it. What is a high risk? Generally, when new technologies are used, when you use AI for the first time or other technologies where personal data is processed, and you don't know exactly what that means. And then, of course, as we mentioned before, from the type, scope, circumstances, and purposes of the processing. So, for example, for automated individual decisions, this could be something that could lead to a high risk. For high-risk profiling, in the case of extensive processing of sensitive data and when extensive public areas are systematically monitored. These are the criteria that we discussed already before. What are the possible impacts of the processing on the data subjects? This is also a question that we get a lot. So it's the inability to exercise rights or access certain services or opportunities. It's a loss of control over the use of the personal data. It's a loss of confidentiality. It can be discrimination, identity theft, or fraud. It could lead to financial loss, reputational, physical damage, and it could also be that pseudonymized data might be re-identified, and then that would be again a loss of confidentiality and loss of control of the own data. So next slide. So in these cases, the law requires to perform this DPIA. And this DPIA, the aim of that is to help the controller to assess the risks and to take the appropriate measures to mitigate these risks. So the DPIA shall contain a description of the planned data processing. So what is planned and how shall this processing look like? Most of this information can be taken already by the record of processing activities. So it's the same thing. So purpose and categories of data, etc. Then you need to do an assessment of the risks of the personality. So based on that information, and then describe also the measures that are taken to protect the personality or fundamental rights. So this is the content of this DPIA. The controller must do this DPIA before the data processing, so not after, it must be done before. And if, despite all the measures taken, there is still a high risk for this processing activity, then the Federal Data Protection and Information Commissioner, so the authority, must be consulted, except if the organization has appointed a formal data protection officer, as I mentioned before. So that would be the benefit of having a data protection officer. There are also some exceptions for private controllers not to do, not to consult. The controller is legally obliged to process the data, or the controller is subject to a code of conduct that meets all the requirements. In these cases, there is an exception. Now, the the authority has published some more information about the DPIA. They have published a guidance also on this matter, and also a template that could be used to perform such a DPIA. So if you want to go, and you have here the link. Okay, next slide, please. So the record of processing activities, that's what I mentioned at the beginning. We had before an inventory of data files or databases. Now it's an inventory or record of processing activities. And this is new. So the controller and processor must keep this record of processing activities. The law defines the minimum content. Probably, I mean, you are aware of this if you know also the GDPR. So you have to provide the controller's identity or processor identity, the purpose of processing, description of the categories of data subjects and of the personal data, the categories of recipients, retention periods or the criteria. To determine such retention periods, then you have to describe the general technical and organizational measures, and in case of cross-border data transfers, also indicate based on which safeguards this data transfer takes place. So this is the minimum content that needs to be included in this record of processing activities. Now there are exemptions for companies. In Switzerland, this is the case where the company has less than 250 employees as of 1st January. And the data processing is only a low-risk data processing, or meaning it's not a high-risk data processing. And the criteria, again, the same. So no extensive processing of sensitive personal data, no high-risk profiling, but also no other high risk for data subjects. So this is for private organizations. Federal bodies, they always need to maintain a record of processing activities and register this record with the authority via a certain link. For private organizations, there is a requirement to keep that record internally, but there is no requirement anymore to register, to notify the authorities about the inventory. Yes, so next slide, please. So one question that we get a lot is, why should we maintain a record of processing activities, especially for smaller organizations that might fall under the exception? My personal view is that it's in any case good to have this inventory because it's the basis for many things. So it's a basis for privacy by design. You need to know what you do in order to know if you have to take any measures. You need to know what you do in order to determine if you have to perform a data protection impact assessment. You need to know what you do if you want to write a good and complete privacy notice. And also if there is an access request, then you need to know what you have, and you need to know how you process the data, because then you have to tell people what you do and how you process the data, which is information, the same information as you would provide in a privacy notice. It's a basis also for handling data breaches, because again, if you don't know what you do and have not documented it, then it's much more difficult also to provide then answers and to know what measures needs to be taken. It's a basis for data flow management. Again, you need to know where the data is flowing in order to know whether if you have to put in place some safeguards and transfer mechanism, and it's generally the basis for data management and compliance. So if you don't know what you have, you can also not be, it's difficult to be compliant. So these are the reasons why I personally always think it should be good, or it's good to have this inventory. But of course, if an organization falls under the exception, then there is no need to do it. Next slide, please. So just as recommendations, so for each organization, determine if you fall under this exception or not. So for smaller organizations, this is of course the case, not for the bigger ones. If you decide not to keep a record of processing activities, my recommendation is to document the reasons for this. Get an overview of your filing systems and processing activities if you have to do one at corporate and functional level. Document these processing activities and the filing systems using a template. You can use whatever tool, Excel, Word specific tools, databases, etc. I recommend always to involve the appropriate functions such as HR, marketing, IT, etc. Then once you have that, and of course that's a step beyond, but my recommendation is always to assess these entries for completeness and compliance with data protection requirements, so that you do really an assessment, and there is a benefit also of having such an inventory. Assess also if a data protection impact assessment is required, and if that is the case, keep that documentation for at least 2 years. That is what the law requires. Allocate also the responsibilities internally to maintain the record up to date, and establish also a process to regularly review this inventory and perform any required amendments. Next slide, please. So data security and TOMS. So as I mentioned, there is not a big change from the previous version of the law. Controllers and processors still have to ensure appropriate measures, and these measures must be appropriate to the risk. So there is this risk-based approach here. There are some measures, minimum measures, that are described in the ordinance to the law, but the ordinance basically contains some criteria to decide the level, or to determine the level of risk, and then to determine the necessary measures. But it's quite open. It's not very detailed. Then there is also an obligation for large-scale automated processing of sensitive data or high-risk profiling to keep a log, and also to create some processing policies. These are additional requirements that needs to be done. This goes also beyond what we know from the GDPR, and it's to a certain extent it's also the application to the record of processing activities. But you have really to carefully do this analysis if you have to do these logs or not. The Federal Data Protection and Information Commissioner has issued guidance on the technical and organizational measures, which is a quite good guidance. It's a quite comprehensive guidance, which includes technical aspects, but also organizational aspects. They have also provided technical recommendations for logging, as well as processing policy templates. So you can go to this to the site of the FDPIC. I have put the link here, and you can find all these documents that can, lead you through the process. Again, here just to know if the technical and organizational measures are not established as they should, then there is a risk of a fine, again, up to 250 Swiss francs. But again, it's just an intentional failure. Okay, next slide, please. On this slide, you see the criteria, to assess the level of risk and to assess the level of TOMS, let's say. So first of all, you have to determine the protection needs of the personal data, and the law describes the criteria. You have to see what types of personal data is processed. So you should somehow, do a classification. So you should know, is it sensitive data? Is it just personal data? Is it pseudonymized data? So what is the type of data, and what is the form of the data? And then also look at the purpose, nature, scope, and circumstances of the processing, as we discussed before. So these are the criteria to assess the level of risk. Determine the risk, the personality or rights of the data subjects. So look at this cause of the risk, the main hazards, and the measures taken already, etc. And then finally determine the terms appropriate to the risk. So once you know you know what you have, you know what type of risk you have, then you determine the appropriate terms to mitigate these risks. Well, this is just a summary, but if you go into the ordinance, you can see much more details about this, and I recommend really to go through this criteria in order and to document also what you do in order to ensure that you really put in place the appropriate terms. Okay, next slide, please. The data security breach notification is a new requirement under the law, as I mentioned. So controllers must notify the authority of a breach of data security if this breach is likely to lead to a high risk to the data subject. So we have again this high risk. So it's not a risk like under GDPR, it's a high risk. And it must be done as quick as possible. Again, the law does not specify within how many hours this needs to be done, but just says as quickly as possible. The concerned data subjects must be informed if this is required for them for their protection. So otherwise not, or if the authority requests to notify the data subjects. So that's a little bit different from the GDPR. But yeah, similar. The processors must notify the controllers. They do not have to notify that to the authorities. The minimum content is mentioned in the law, so you have to provide the nature and consequences of the breach, and also to explain what measures have been taken or what measures are planned. There is a link which I put here, so you can, if there is a breach, you can notify this breach via this link online. If it's not possible to provide all the information as quickly as possible, you can do a first notification, and then once you know more, then update this notification. So that's the same concept as we know under the GDPR. Next slide, please. We asked the Federal Data Protection and Information Commissioner on 9th of September how many notifications were done online. In 1 year, these were 253, which is really not a lot. So these were notifications done and via online, and then via other channels, less than 36. The Information Commissioner recommends 2 organizations to learn about best practices to protect them from hackers. So implement the appropriate technical and organizational measures, but to be updated and always to follow the new trends. To prepare a standard document or protocol for the event of a data security breach, so that you can really capture all the information in a systematic way, and also to implement procedures for managing such incidents, including also, they say, a realistic way of contacting data subjects. And I think this is something that generally is recommended for all organizations, to have really a plan in place with some tools already, or some templates, if such a breach happens, so that you are really ready to know what to capture, how to capture it, who is responsible for what, and who would then do the notification, because as soon as possible or as quickly as possible is as quickly as possible, so we cannot wait a long time. Next slide, please. Outsourcing, as I mentioned, the outsourcing obligations are not really new. We have them in the law already. So the controller may assign by contract or legislation the processing of personal data to a processor if the data is processed in the same way as a controller would be allowed to do, and if no legal or contractual confidentiality obligations prohibit this assignment. So these are the conditions that we had before in the law. The controller must ensure that the processor is able to guarantee security, so must perform a due diligence. What is new is that the processor may only transfer the processing to a third party, so sub-processing, with a prior approval of the controller. So the processor may only subcontract with the prior approval of the controller, which can be a specific one or can be a general one. And we know that from the GDPR as well. The failure to comply with these requirements may lead again to a sanction. Of course, again, only intentional assignment without complying with these rules. So as a process, first of all, determine if the service provider is a processor at all, so if they really process data on your behalf. Then perform a due diligence to see whether the security measures can be applied and are sufficient. Enter into a data processing agreement with the processor that specifies all obligations, and if there is an international data transfer, then we need to have also some additional measures, so standard contractual clauses or other transfer measures. Next slide, please. So as I just mentioned, yes, cross-border disclosure of personal data is restricted in Switzerland, as it was before. There are adequate countries. So what is new, before the Data Protection Information Commissioner had a non-binding list of countries. Now the list of countries is in the annex to the ordinance of the law, so it's a binding list, and we have these countries listed there. What is new is that as of 15 September of this year, the Swiss-US data privacy framework applies, and so the transfer from Switzerland to certified US companies is now possible without any further restrictions. If the transfer is performed to a third country that is not adequate, then we have the transfer mechanism like standard contractual clauses, and in Switzerland we use the EU standard contractual clauses with an addendum. And in addition here, of course, we need to perform transfer impact assessments, so we have to make sure that the foreign government cannot access this data. Respectively, we have to take the appropriate measures to mitigate this risk. Then there are exceptions, which are the same as before. So there is explicit consent, performance of a contract, etc. And with these exceptions, such a transfer would be possible as well. Okay, next slide, please. Again, here are some measures to be taken for everyone. Just make sure that you get a good overview of the services, of the service providers, of the data flows to service providers, but also within your organization. Review contracts that you have with these recipients of the data, insert the data protection clauses, make sure that you do the due diligence, and make sure that you have all your transfer mechanism in place with the Swiss addendum, or as I mentioned, also the Swiss-US DPF is now available. Here again, if data is transferred to a third country without taking the appropriate measures, and also if data is outsourced, as I mentioned before, without taking the appropriate measures, these are violations that could lead to a sanction. Okay, next slide, please. Go a little bit quicker now because then we have then still a little bit time of questions. This is just a recap, recent developments, opinions, guidance. I mean, there are many, of course, press releases, etc. You can look on the website. You can see all publications of the authority. I just summarized once again the most important ones. So the decision about the Swiss-US DPF, then this guide on the TOMs and recommendations for logging. Then there was a press release also of the FDPIC that said that the Swiss Data Protection Act is directly applicable to AI-supported data processing. So irrespective of the approach that will be taken, so there is currently an evaluation ongoing if there should be a specific AI law or not. But irrespective of that, Data Protection Act is applicable directly. And then, as I mentioned, there is also this fact sheet on the Data Protection Impact Assessment, so DPIA, that was published. But we mentioned all of these before already. Okay, next slide, please. I will briefly talk about some conclusions based on some investigations performed by the authority. Next slide, please. Yes. So in May of last year, the IT security service provider Explain, who works for different federal and cantonal bodies, was subject to a ransomware attack. And consequently, a large volume of data stored on an Explain server, including sensitive personal data, was published in the darknet. So the authority opened an investigation into the Federal Office of Police and the Federal Office of Customs and Border Security and Explain to mainly assess the circumstances in which the data was transferred to Explain and then afterwards also stored on Explain servers, so to see if everything was done correctly. Now, the conclusions that can be drawn from the final report of the authority is basically that they say, okay, first of all, data minimization is really key. Secondly, it's important to document data flows, anonymization, and all the access modalities. Processors must implement concepts for deleting the data on time and raise awareness and train their associates, and also regularly conduct internal and external audits. And the controllers also must regulate the processing activity, the processing by the processor in the DPA. So this is very important. It was not done here in this case. The technical and organizational measures must be described in this contract, and the controller must also instruct and monitor the processors. So these are the main conclusions that we could read out of this final report. There was another case, next slide please, for Digitech Galaxus, which is an online store in Switzerland. So in spring 21, the authority opened a procedure to inspect the processing of customer data of Galaxus. And so the investigation was performed because some data subjects said that they were required to accept all the processing activities described in the online store's privacy policy before they could go ahead and place an order, and they could not do that as a guest. They had to register. And so the final report came out in April 24, and the authority concluded, among other things, that Galaxus was violating the principles of transparency and proportionality, so data minimization, and issued a number of recommendations to mitigate this or to remedy these deficiencies. Next slide, please. And that is so. So the recommendations, basically, concept of personal data. So in principle, in Switzerland, the relative approach applies. So data that is linked to a unique identifier of the end user is considered personal data, including hash values. But if there is no connection to an individual by also technical or contractual means, then the individual cannot be identified. So this is a relative approach. What is interesting, the commissioner said that personal data and purpose of collection must be linked. So so you cannot just list, all personal data that is collected and then separately all the purposes that is collected, but you have to link what personal data is used for what purposes, and this is a consistent approach also as required in the EU. Then the authority said also that the information on data processing was not accurate because this notice described or included purposes or processing activities that did not take place. So they said this is misleading. So individuals must expect that identified data processing takes really place. Otherwise, this would violate the principle of good faith and transparency. And finally, they said also that the obligation to create an account and not to be able to buy as a guest also would violate the principle of proportionality. So you have, it must be ensured that you can buy as a guest. So again, the general conclusions, the principle of data minimization and proportionality must be observed. So that is something very important. And also the privacy notices must clearly state the processing activities and the purposes for processing, and so that you can just say the authority really focuses a lot on data minimization, proportionality, and also the transparency obligations, to be very clear on this. Okay, so that was my last slide. And let me see now if we have some questions. And I think we have. I don't know, Dan, if you join, or I can also take a question.
Hi, Daniela. Yes, we've got a few questions in, but before I ask you a couple of them, just looking at the time, I just wanted to say a big thank you, Daniela, for that presentation. Incredibly informative. We really appreciate your time. So we've had a few questions in during that presentation, which I think are relevant. We've had one from Alessandra, who asks, what is the difference, if any, between extensive processing under the FADP and processing on a large scale under EU GDPR?
So what is the difference between extensive processing and large scale?
Extensive processing under the FADP and processing on a large scale under EU GDPR.
Yeah, I mean, I think that large scale processing is an example of extensive processing, right? So I think that is the same. But extensive processing, it's difficult because it's not really defined, but it can be large scale. But I think it's really the opposite of occasional and of limited processing. So if it's not occasional limited, it could be interpreted already as extensive processing. But it's an example of extensive processing. That would be my answer.
Excellent. Brilliant. Thank you, Daniela. We have one more question before we finish from Shelley Ann, and they have asked, what circumstances or examples would be considered as a high-risk security breach for the purposes of data security breach notification?
Yeah, as I mentioned, so this is really an assessment that needs to be done case by case, but for sure, if there is sensitive personal data involved, then that's for sure high-risk processing. But also if there are profiles of people that might not include sensitive personal data, but do have really a lot of information about the person that really, gives a lot of, let's say the data sets is big, the volume of data is big, then that might be also a high risk. And then it depends a little bit on the circumstances also. It depends, where the data is, if the data is published somewhere, if the data has really gone to the wrong people, that could maybe do a greater harm. So that could be also high risk. So it's really a case-by-case assessment that needs to be done.
Excellent. Thank you, Daniela. I think that unfortunately we're just out of time for any more questions. Unless you think you can, I don't know if you can see the final question, Daniela, unless you think we can answer that in under sort of 30 seconds. The second question from Shelly Ann.
Has the fine, is that one? Has any fine been issued so far under the new Is it this one?
Yeah, we can ask that question. Has any fine been issued so far under the new Swiss Data Protection Act?
Well, there have now been judgments so far, so there is nothing known yet about fines. It's a little bit early now to answer this. And maybe also one thing, that the fines are issued by the cantonal courts and not by the authority. Maybe that this just as a difference. But I'm happy if you have these questions. I mean, I think we did it last time as well, Dan. If you want to send that to me, I can provide you with an answer for your questions.
Brilliant.
Yeah.
Excellent. I was going to say to our audience, I know that there were a couple of questions that came in beforehand that we didn't have time to get to. Please do send any questions or comments or queries that you have for Daniela over to Daniela. We'll send you her contact information after this session. But to close, thank you so much, Daniela, again for your time today. It's been a pleasure spending an hour with you and listening to your insights today. Thank you very much to our audience as well for being with us and for those wonderful questions. Daniela, I'll hand over to you for any closing comments that you have.
No, yeah, thank you very much. It was a lot in this hour that we covered. So, but as I said, please send me your questions. I mean, we have the questions here also. I'm happy to answer those for you.
Brilliant.
And otherwise,
thank you very much
for being here.
Thank you, Daniela. Well, have a lovely rest of your day, everyone, and yeah, we'll see you soon.
Thank you. Bye.